Okay, welcome to this evening's webinar. Do I need a will? The simple answer to that is going to be yes, obviously, but I'll take the next 45 minutes or so to explain why that is. Like I said, today's webinar is going to be projected for 45 minutes. I never know exactly how long something will last. Sometimes it's a little shorter, sometimes it's a little more. I do my best to keep it inside of the 45 minutes that I promised. It is a one-way communication, so you can hear me, but I can't hear you. There is a chat pane on the right where you're able to put up questions. I will take as much time as I can to answer them afterwards. I recommend you put the questions up throughout the session so that you don't forget about it or gets replaced by other issues. Other people, I believe, do not see your question or your name, so you don't have to worry about any confidentiality issues, and I will not address you by name when I respond to them. This is being recorded, so while there'll be people that come in late, maybe leave early, I will be emailing a copy of the recording in case you miss any parts. As I said, I'm going to stay afterwards to answer as many questions as I can, or answer all the questions that you have. I'll take as much time as needed. And then afterwards, either tonight or tomorrow, you should be receiving a survey. And I'd appreciate if you could take a couple minutes just to answer those questions for me. Let me know the good and bad sort of the presentation so that I can tailor future ones to better suit your needs. My name is Brad Micklin. I am the managing member of the Micklin Law Group. I've been practicing a little over 18 years now. I am licensed in New Jersey and Pennsylvania state bars, as well as both state and federal court systems. I started my practice as a judicial law clerk working for a judge in Bergen County. Spent a year doing that, and then I moved on to doing complex commercial litigation with Kessler and Associates in Clifton. After a couple of years there, I realized I'd prefer working for people and families as opposed to businesses, so I opened my own practice in 2001. I was a general practitioner at that time, but I quickly focused my practice into divorce, family law, and estate planning. Realized it's not possible to be good at everything, so it's better to concentrate. I currently handle the high conflict and high net worth divorce cases, as well as the complicated family and estate litigation of the firm. The Micklin Law Group itself is also concentrated solely in divorce, family law issues, and estate planning and litigation. We have two associates, Rachel Isaacs, who is our senior associate, and Richard Muglia, who is our junior associate. Alyssa Musso has recently joined our firm. She is a law school graduate waiting on her bar results. We have Carmen Figueroa, who is our client service manager, and several off-premise administrative staff that assist us on our day-to-day needs. So let's first talk about the basics. What I'm going to be discussing throughout this webinar is why you need to plan and the problems if you don't plan. But let's first talk about what you should be planning. And the first is a last will and testament. The last will and testament is the document that tells the world what you want to happen to your valuable assets when you pass. It may or may not include trust planning, which we'll talk about in a moment. And it must conform with the statutes for its form and its execution, meaning how it says what it says and how it's witnessed and signed. If you do not adhere to the statutory formalities, it will fail and you will lead to either intestate, which we'll talk about in a second, or possibly a will contest, which we'll get to at the end of this session. So let's talk a little bit about intestate succession. And the statute is NJSA 3B:5-3. This is the statute that determines what happens to your property if you die without a will or your will is later invalidated. It is a very complicated pattern of distribution. Let's take a look at just how it's worded. I'll try to give you a clear, concise explanation as I can. The first three are three different scenarios that are contemplated under the intestate statute. The first is if you pass with a surviving spouse or partner. You have no children, you have no parents that survive you, and your spouse or partner has no children. Under that scenario, your spouse or partner receives your entire estate. It gets more complicated when you have blended family issues. So next is simply if there's children, if you're sharing children. So let's say you have a, I'm sorry, it's not surviving children. If you pass with a parent that survives you, but you have no children, the way it's broken down is your estate. The first 25% of your estate will go to your surviving spouse. Not less than 50,000, which means if your estate is only 50,000, they would probably get all of it. But first 25%, not less than 50,000, not more than 200,000, plus 3/4 of the balance. Now, if you have a situation where you have other surviving children, so let's say you have children who are you and your spouse's or partner's children, or your spouse has other children that are not your children, or you have other children that are not your spouse's or partner's children. Under that complicated fact pattern, your spouse would receive the first 25% of your estate, but not less than 50,000, not more than 200,000, similar to the one before, plus 1/2 of the balance of your property. Now, the reason why this is such a mess, aside from this complicated breakdown, is figuring out the 25%, not less than 50, not more than 2, plus balance, in and of itself is a very complicated pattern of distribution, especially in a smaller estate. But not all of your property may be considered probate property. And we'll talk about that a little bit later. But probate property is what passes in your estate. Non-probate property is what you pass directly to somebody, like real estate that's held jointly or a retirement account with the beneficiary named. So you have this complicated fact pattern, and you may have a complicated distribution of property because some of it may apply and some of it may not apply. So if you don't have a will, the people that you want to leave your valuable property to have to go through this calculation to figure out what they are entitled to, if anything. Now, if you pass and you don't have surviving spouse or partner or children or parents, then it passes to your next closest family member and then down the line to whomever that may be. It's not something that you really want to leave your loved ones having to deal with and try to figure out. So it's obviously one of the significant reasons why you'd want to have a will in place. Next, we're going to talk about trusts. First, we'll talk about the classifications and what they are. I think a lot of people have a misconception of what a trust is. I think a lot of us carry this old concept that it's this really rigid, formal thing that bankers use or banks do, and it's complicated and costly. And I mean, to some extent, it is complicated and it can be costly, but it's not as formal and rigid as it used to be, or as many of us think it is. A trust is simply a legal entity that's created like a corporation. It is separate and apart from yourself. It will have its own tax ID number, and it'll be treated like its own legal entity or person. There are two main classifications of trust. There are testamentary trusts and there are living trusts. Testamentary trust is created inside of your will, so it does not exist. It is not formed until you pass and your will is in probate. The purpose is generally to safeguard either certain property or certain people that aren't going to inherit your property. Most common will be children. A lot of people, most people, don't want young children to receive large sums of money without discretion over how to use it and where it goes. Most commonly, next to that would be individuals with disabilities. Disabilities can take many different forms. Obviously, there are mental and physical disabilities, but there could be drug addictions, spending problems. There are many things that are nowadays considered disabilities that may not have been looked at such 10, 20 years ago. You may have individuals that either receive or may receive governmental benefits due to these disabilities that may be jeopardized if they receive property directly. So you may put it into a trust. A special needs trust is most commonly the one that you would use for that circumstance. You may have relatives or loved ones that have financial issues or creditors. You may want to ensure that their valuables are not taken to satisfy their creditors. It's commonly called a spendthrift trust that would protect them from that. And then divorce, which is similar to a creditor. A lot of people want to protect their valuables that they're giving to their children, or actually anybody, I guess. It doesn't have to be children, it just commonly is, to their children in case that child has a spouse or a partner and later finds themselves getting divorced. Most people don't want their property going to the ex-spouse or partner. Then there are living trusts. Living trusts are created now. That's why they're called living trusts. They exist now. They have many benefits. One of the most significant benefits is it eliminates probate. Probate, as I was saying before, is the process that your estate will go through when you pass. It can be a very lengthy, very expensive process. There are often significant legal fees associated with it, costs to the process itself. An executor fee for whomever is handling your estate gets a percentage of it. And there are often litigation, like will contests that we'll talk about later, that can be all avoided by having your property transferred to a living trust. And generally speaking, depending on the type of trust that you set up, and we'll go more deeply into this in the next slide, but does not always reduce your estate tax. A lot of people will put money into trusting and would reduce taxes, but only certain types do, and you need to make sure that you choose the right one if that's your intention for the transfer. Now, there are going to be a lot of tax issues like gift tax, capital gains taxes that we're not going to really touch on, but they are also benefits to having trust or trust planning in place as part of your estate planning. And one last benefit to trust generally is because they are treated as a separate entity, they are taxed separately from you or the individual that's setting up, transfer the assets. So oftentimes you can maximize capital gains tax issues. You can reduce income tax issues if you're at a high bracket. A lot of benefits to proper tax planning through trusts. All right, so let's look at the types of trusts. There are two main types of trusts. There are irrevocable and revocable. And the names sort of suggest how they operate. Irrevocable means if you transfer property into it, you cannot keep control of it directly, cannot have direct control over it. You cannot take it back. And revocable obviously means the opposite. Revocable is commonly used as a shield for taxes. It will help eliminate estate tax issues if you have a large estate, capital gains if you bought property at a very low price that's appreciated significantly, Medicaid protection if you believe that you or a loved one or beneficiary may have the need for Medicaid or significant healthcare costs in the future. Transferring assets into a trust will enable that person or you to receive Medicaid benefits more quickly. There is a 5-year look back that we're not going to get into, but be aware that that's an issue if you are using trust planning as a potential Medicaid vehicle, that you need to be aware of the 5-year look back period, and you should seek some counseling before you actually transfer property. And lastly, as I said before, it simplifies probate because it eliminates the need to probate at least the property that you've transferred into the trust. So many people will transfer all their property into one form of a trust, either revocable or irrevocable, for the point of simplifying probate and eliminating the probate costs, which can be significant. The most common type of irrevocable trust that you will see is a life insurance trust. And the reason is, I think, twofold. One is life insurance can often be a very large, if not the largest, asset that people receive in a will or in an estate, and it can often trigger significant tax consequences. And secondly, because irrevocable robs you of your ability to retain control over the property, you're not really giving up much when you put a life insurance policy in an irrevocable trust, because the policy has no value to you. Assuming it's a term policy, it has no value to you until you pass, and then it becomes funded. So you're saving all the costs and fees and taxes associated with probate and estate, but you're not losing control over any valuable assets that you may want to use during your lifetime. Revocable trusts are in most senses the opposite, in that the grantor, the person that's giving the property, does not lose control or the ability to benefit from the property. It's usually intended to avoid probate. It's the most common use. It facilitates having the loved ones or family members immediately receive property upon your passing, and eliminates all the significant costs that can be associated with probate. It's also used by some people that either have a disability or are concerned they may develop one, or their beneficiaries or loved ones may develop a disability in the future. It allows you to name successors to control your property in the event that you become unable to. That can eliminate some guardianship issues, which we'll touch on a little later in the presentation, as well as litigation that often erupts when there aren't documents in place. Now let's talk a little bit about advanced directives, and there we'll go into the specific types of directives, but basically let me give you a little background about an advanced directive. People usually think of living wills, but it's a lot more in depth than that. An advanced directive of any sort is a document that's created to give instructions when you become disabled or incapacitated. It will not be utilized until a physician has determined and declared that you are incapacitated or disabled. So you do not need to worry that any of these vehicles will rob you of your ability to make your own medical decisions while you are capable. It's simply when you are deemed incapable of doing that. The purpose is to appoint, depending on the documents, which we'll get into, one is to give instructions and one is to appoint a decision maker. My general recommendation is you have both, and I'll explain in a moment why that is. And lastly, the intention is to preserve your dignity and autonomy. A lot of people have very strong beliefs about their medical care, treatments that they do and don't want. Many people have very strong religious convictions about what they are and are not interested in having, or maybe even what they are permitted to have. Conversely, and a lot of people don't think about this, the people that are going to be making medical decisions for you if you are unable may also have very strong personal feelings and religious convictions, and those feelings and convictions can differ significantly from yours. So without knowing that, if the wrong person is put in control of your decisions, or that person is not given specific instructions as to what your wishes and values are, then you're going to have serious complications in obtaining the medical care that you would have wanted without these documents. All right, so let's take a look at the two main documents. There's a living will and a medical directive or medical power of attorney. I'm not crazy about these terms because I think that they are often confusing to people, because a living will has nothing to do with your will, and a medical power of attorney has nothing to do with a power of attorney. So I'm going to first explain the other documents, and then we'll go through these two documents just so that it's clear. Obviously we talked about what a will is, but a power of attorney is just as it sounds. You're giving somebody the power to work as your attorney. They can access your accounts, buy and sell assets, start and finish litigation, do anything that you could, enter contracts, break contracts, anything that you could do on your own. There are two kinds of powers of attorney. There's a durable power of attorney and a springing power of attorney. Durable power of attorney is effective when you sign it, and it lasts until you revoke it. That's why it's called durable. And a springing comes into effect if you become disabled or incapacitated. It springs into effect. Durable is effective when you sign it, but it can only be used by the individual who's named in it when it's delivered to them. So I recommend, if you're going to use one, unless you have the absolute utmost trust in this person, that you not actually physically deliver it, but advise that person where it can be located in case it's needed in an emergency. I don't generally recommend springing powers of attorney for most people, because the purpose of making any power of attorney, whether it's financial or medical, is to eliminate the difficulty your loved ones and family will experience when there's some kind of tragic event that they're dealing with. Springing power of attorney brings the added level of proving that you are in fact disabled. And if a it can't be determined, or if there's some dispute to it, then the complications you sought to avoid by having the power of attorney may cause the same ones. But now, getting back to the advanced directives, again, what I was just talking about are not advanced directives. There are financial powers of attorney and the will for your basic estate planning. A living will, again, very distinct from an actual, is a document. It's an instructive document. It's intended to give specific directives to medical professionals for the care that you do and don't want. Like, do you want experimental surgery, pain medication, respiratory support, life support? What do you consider, if anything, to be brain dead, or how you want it to be treated? The dreaded pull the plug issue. These are things that are embodied in a living will. The purpose is twofold. One is to ensure that your values and beliefs are sort of codified, that they're in writing, so that nobody has any question to what you do and don't want. And second, and possibly more importantly, it helps the family or loved ones have to make these decisions, because there can be nothing worse than having to make very difficult, life-altering or life-ending decisions for a person and not know what that person wants, to be the one making these decisions. When you put in your instructive directive in a living will, you're taking away the burden of that person making these decisions, and you're making them for him or her. Medical directive or power of attorney is a document where you name or appoint somebody to be your medical director. It should include the living will directive also, so that that person is guided in the decisions to make, but it does not necessarily need to. There are two separate and distinct documents. You should have, I would say, up to at least 3 people named as medical directors. And I generally don't recommend that they work together. You don't want 3 people working together. I don't even usually recommend having 2 as co-directors, but 3 people in case one that you name is not able to or unwilling to make these decisions, to step into that role. You want a second and a third choice for the hospital or court to go to, so that these decisions and wishes can be carried out for you. Now, let's talk about some tax issues if you fail to plan your estate properly. And we're only going to touch on tax issues because tax issues are very, very complicated, difficult issues, but they're probably the most important for your contemplation of why you should or shouldn't plan your estates. Things we're not going to talk about. We're not going to talk about gift taxes, whether or not, whether they exist. And I know a lot of people have this misconception about the $10,000 a year or $13,000, because Jersey doesn't actually have gift tax. But we're not going to go much into gift tax. We're not going to go into capital gains tax. We're not going to go into inheritance taxes. Not to say that these aren't important. They are. They're very important. But there's too much to go through. The main point to get is any estate may have significant tax issues, and you may not even be aware of them without proper planning. Again, the theme of this whole session is plan for your estate, talk to professionals. So turning to the tax issue we are going to talk about. And many of them have been in flux over the past several years and may continue to be in the next few years. So it's also important to keep up to date on this. The federal and state exemptions. Federal exemption is $5 million, state exemption is $675,000, which simply means if you have property that exceeds these numbers, you will pay either a federal estate tax or a state estate tax. Now, a good majority of people don't really have to worry so much about federal exemption. Either they don't have estates that large, or if they do have that much assets, they already have advisors planning for their estate, but not always. I handled an estate where an individual passed with $15 million of real estate and had no will, which means almost 50% of that $15 million was paid in estate tax. And this was back when the exemption was $1 million years ago, not 5. So $7 million in taxes is just brutal, but it happens. So now New Jersey state tax is a much greater concern, and it wasn't up until a few years ago, because it was sort of linked to the federal exemption so that you didn't necessarily have to plan so much for it. But now you do. Now it's separate and apart. And while you may not believe that you have an estate at that value, there are a lot of things to contemplate. Insurance policies, for instance, are often large sums of money that can escalate the value of your estate without you realizing it. Real estate appreciation. Many people, many elderly families have invested in real estate many years ago at very low and then saw a significant appreciation that's maybe not contemplated. Stock market hopefully is on its way up, so there's going to be a lot of investments that may be picking up, and you add these all together, and it's not so difficult to see you having a estate beyond $675,000. Now, New Jersey has a mildly convoluted way of figuring out the estate tax because it's a certain percentage on a certain portion, then a certain percentage on another portion. On average, I tell people to expect about 10% of anything above 675,000, and that's aside from the costs and fees associated with probate and the executive fees and everything we talked about earlier. So that's usually another 10 or 20%. So lack of proper planning can have anywhere from 10 to 30% of your estate consumed in taxes and costs. Ways that you minimize this, obviously planning, first of all. You can also gift. New Jersey has no gift tax. The federal level, and I apologize, there's a typo here, it's supposed to be $5 million. Most people can gift at least $1 million in their lifetime without any tax consequence. I know there's a big misconception about this 10,000 a year. It's actually 13,000 a year, I think now, but that has nothing to do with paying a tax on the gift. People confuse the two. It's more of a reporting mechanism, so it's tracked, but you can gift a significant sums of money without any tax burden and minimize the future tax issues for your estate and your beneficiaries. There is a look back period. Again, I'm not going to get into it. I put it up so that you're aware that if you're going to use gifting as part of your estate planning, that you want to be aware of this and get some consultation on it. Trusts, as we talked about before, very good, relatively easy ways to minimize the tax consequences of your estate. And then joint tenancies. Most commonly, you'll have real estate held in a joint tenancy, but you can really do anything in a joint tenancy. You can it's by putting somebody's name onto an asset that you hold. Bank accounts, stock accounts, car titles, anything can be converted into a joint tenant so that that property will pass immediately to the other person upon your passing and is outside of probate. So it's not part of the taxes, not part of the cost. One note to make, if you are going to use joint tenancy, it's a very powerful, very easy way to eliminate costs and taxes and plan your estate. But you want to make sure that if you're putting somebody on as a joint holder to an asset of yours, and your intention is that they get it after your passing, you need to make that clear somewhere. Now, it can either be in the title that you're changing, but more likely it's going to be or could be in your estate planning documents. New Jersey has some probate cases that say if an asset is made into a joint asset, but it was for the testator or the decedent's convenience, then it goes back to the estate and not to the individual. And in my experience, courts bend over backwards to find that it's been a convenience because they generally see a large sum of money from an estate going to one person, and many beneficiaries who do not share in that cause a lot of upset and a lot of litigation. So if it is your intention that they receive that property, you need to have proper estate plan documents that indicate that. Now let's take a switch in focus. The other part of our practice being divorce and family law, I think it's important to see issues that arise in your family law situations if you do not plan your estate properly. First is how a divorce can affect both you and your spouse. And generally speaking, when you file a divorce, if you have a will in place, your will is revoked by operation of law, which means the law says it no longer exists. Now, normally, if you were married, or not normally, commonly, if you're married, you'll have a will that leaves everything to your spouse. So many would think that this revocation is actually a helpful, positive thing, but it's really not, because if you recall the beginning of this, we indicated that if you don't have a will, your property passes by intestate succession, which means the first 25% will go to your spouse plus a percentage of that amount afterwards. So if you file for divorce, it's most likely your intention that your spouse not receive anything. So without having a will in place, that's not necessarily going to happen. I urge all of my divorce clients immediately upon opening a divorce case that they need to execute a new will. Second issue is sometimes people will have a will that seeks to disinherit their spouse. It could be that there is maybe significant premarital property that one person owned. That person may have other children from a different relationship they may want to plan for, and maybe their spouse has significant assets. But the law, and I cited here 3B:8-1 says if you eliminated your spouse, if you disinherited your spouse entirely from your estate, your spouse has an elective share of up to 1/3 of your probate estate. Now, I put the term probate in the quotes because it's important that you remember that distinction, because only what goes through your estate is subject to the elective share. Remember, we said if you do trust planning, for instance, it removes property from probate. So if you improperly disinherit your spouse because your intention was that they not receive, and you have proper trust planning in place, then you don't need to worry about the elective share. But if you don't have planning in place, these are the issues that your estate will be faced with. Now let's look to custody and guardianship issues. Now, custody issues, you can't necessarily pass custody of your children to somebody else through your will. That issue is always going to be determined by what's in the child's best interest. It's presumed that to go to the other parent, but even that's not a guarantee. It's a constitutional right, but it's ultimately the court's ability in the child's best interest to make a different award of custody. But what you do accomplish by indicating, especially if you have sort of an unnatural choice for custody of your child, like if there's a surviving parent, but you don't want that parent to receive custody, indicating your custody desire inside of your document will show the court what your intention is. If you are the custodial parent, for instance, your intention for your views of what's in the child's best interest are going to be very significant for a court and assist that court in determining what is best for the child. If you don't indicate your intention or desire, the court has nothing to go on. Second, a lot of families need to realize, unfortunately, there are issues of common accidents where both parents will pass together. If you have not provided for a will that provides who's going to be the custodian of your children, the children will go in, at least briefly, into a foster care system, and there'll be litigation to determine who should be the caregivers. Not something that you ever want to have happen to your children. Now, there's also things you need to consider. You may have different people that you want to handle the custody of your children as opposed to the assets and finance of your children. Like, for instance, you may want a younger family member who has young children to take custody of your children because they have more energy, but you may want your parents to handle their finances because they have more experience. Conversely, you may want the same person to handle custody and finances because you don't want your children to be a financial burden to the people that are caring for them. So these are things that need to be considered, and they also need to be included in your planning so that everybody's aware of what needs to be done. Now, guardianships, these are for individuals who are disabled or incapacitated. Whether or not you have a medical power of attorney, you still can have a court-appointed guardian if you lose your ability to make decisions. And the reason is a power of attorney, whether it's financial or medical, gives an individual the ability to work on your behalf, the power to work on your behalf, but not the requirement to actually do so. A guardian is a court-appointed agent who has lawful responsibilities imposed upon them to make decisions and to act in your best interest. They're also required to report to the court at least annually. So it's an affirmative obligation that's given to somebody. Now, that's going to be done by a court process, whether or not you have planning. But if you have proper planning, your documents will once again show the court who you intended or who you would want to fill these roles if you were unable to specify to the court yourself. Now let's look at will contests. Will contests are very, very common. I think they're becoming even more common now because people are learning about them and um, the success of them. It happens for three basic reasons. One is a will is either invalid or invalidated later by a court. There's a suggestion showing of undue influence, or the individual lacked testamentary capacity. So the first is invalid will or invalidated by a court later is if you don't execute or draft it in conformance with the statutes, as we talked about in the beginning. It needs to be in a certain physical form. It needs to be witnessed in a certain way. If it is not done that way, it will likely fail, and then you pass to the intestate statute. Second is undue influence. If somebody is able to show that there was an unnatural disposition and a confidential relationship, a will could be set aside and property passed either under a previous will or under the intestate statute. Non-natural disposition is most commonly when there is either a spouse or a child that is completely disinherited, um, or a non-family member receiving a good portion of somebody's estate. And then a confidential relationship is somebody who was close to the decedent. Usually it's a house member or a caregiver. And these kinds of situations are actually common. It's not necessarily an improper thing. A lot of times somebody who's receiving long-term care from somebody does wish that they would receive their property. But if you don't have the proper planning, the showing of these two issues, natural disposition and relationship, will lead to a successful challenge. So if you do want to leave your property in what would be considered an unnatural way, you need to have proper planning to evidence that. Next is testamentary capacity, and there's some kind of related because if you are unduly influenced above, then you may not have the capacity necessary to draft a valid will. But it's really separate. Testamentary capacity just means that you have the faculties and understanding of sound mind to know what you have and what you want to do with it. If you become incapacitated or disabled, you may lack that ability. And again, if you're the victim of undue influence, then you also may lack it. For that reason, too, a court could invalidate your will. In order to challenge a will, you need to file a caveat that's to be filed usually within 6 months. And then the burden of proof, this is important. Under the undue influence, if you can simply show an unnatural disposition and a confidential relationship, and it's not that challenging in cases like this, then the burden of proof shifts. And what that means is that the person who was named in the will to receive the property actually has the legal burden to prove that it is not unnatural and that there wasn't a confidential relationship. And that's without proper planning, that's very difficult, if not impossible, because there's nothing exists to prove it. It's sort of proving a negative. It's a situation that's very, very problematic for a beneficiary, a person that's receiving your property. Without the proper planning, you leave them subject to a great deal of litigation and a great deal of cost. And that cost will largely come out of your estate. Whether or not the person who challenges it is even successful, a lot of legal fees can be spent from your estate to that individual, and it further reduces what your beneficiaries will receive. All right, I'm going to close down the presentation in a second, and then we'll take questions.